From Dufferin-Caledon.
Thank you, Speaker. It's a pleasure to begin again what I began in December, and that was, of course, talking about Bill 52, the Anti-SLAPP Legislation or Protection of Public Participation Act. I want to recap some of what I had covered previously. Of course, Bill 52 stands for Strategic Litigation Against Public Participation, which are lawsuits that are pursued for the sole purpose of silencing or punishing those with an opposing viewpoint. SLAPPs are also referred to as litigation chill, which we're going to cover in a little more detail this morning. Part of what defines a SLAPP is the fact that it has a meritless case and is intended more to intimidate or to punish the defendant rather than seek justice for a wrong suffered by the plaintiff. Typically, SLAPPs are withdrawn shortly before trial. However, the trial dates are often drawn out, and by this time, they've served their purpose as they've forced the defendant to go through an extended period of duress, often at great financial cost. What Bill 52 proposes to do is to establish a new legal procedure that can be used if someone is sued for voicing their opinions on matters of public interest. If enacted, Bill 52 would allow the defendant in this situation to move a motion that would allow them the chance to prove to a judge in a timely manner, and I think that's the important consideration here, allow them in a timely manner to prove to a judge that the legal proceedings brought against them arise from a communication they made regarding the public interest. If the judge was satisfied that this is the case, the legal proceeding would be dismissed. However, if the judge was not satisfied, the lawsuit would continue. The judge would also be able to award compensation regarding costs on the motion if they deemed it appropriate. If the judge dismisses the legal proceeding due to the motion and finds that the suing party brought the proceeding in bad faith, the judge may award the defendant damages as the judge considers appropriate. If the suing party has proceedings before a trial, the defendant who has moved a motion under Bill 52 may also supply a copy of the motion that was filed to the court to a tribunal, and the tribunal proceeding shall be stayed until the motion is dealt with in court. Bill 52 will also place a 60-day timeline on the hearing of the motion so that the matter may be dealt with in a timely manner. This is a key factor in limiting SLAPP's negative effect on the court system. It is also important for countering the effect of potentially having tribunal procedures stayed while the motion is before the courts. And I think I want to focus in a little more detail on that 60-day concept, because this is not going to stop people who have actually libeled or slandered someone. What it's going to do is it's going to expedite the process and ensure that within that 60-day period, a decision is made whether it should proceed. And in a way of example, I would like to talk about one litigation chill that is near and dear to my heart and the Progressive Conservative Party, and that is a litigation chill letter that was sent, of course, by then Kathleen Wynne to Tim Hudak, Lisa MacLeod, and the PC Ontario Fund. So the statement of defence all surrounded a couple of comments that were made by my then leader, the member from Niagara-Glanbrook, and my colleague from Nepean Carleton. And they were issued litigation letters. We often call them lawyers' chill letters. And it was basically to tell them to cease and desist speaking any further about a particular issue. And of course, that issue was the gas plants and the decisions made surrounding it. The important part of why I'm bringing this particular example up is this began September 2011. It's still in process, Speaker. So we're now here, March 2015, and this spectrum of Tim Hudak and Lisa MacLeod and the PC Ontario Party still have that legal proceeding, that threat of a legal process continuing hanging over their heads. So on September 11th, during the provincial general election campaign, and for the interests of full disclosure, this is a court document filed in the Ontario Superior Court of Justice. On September 2011, during the provincial general election campaign in Ontario, the Ontario Liberal Party promised to cancel the construction of the Greenfield South Power Plant, or the gas-fired plant in Mississauga, a project formally conceived and approved for construction in April 2015 by the Ontario Power Authority. The construction of the Mississauga gas plant was commenced in June of 2011. In October 6, 2011, the Ontario Liberal Party won the provincial election, including the Mississauga seats in the vicinity of the Mississauga gas plant, and the government proceeded to take steps to stop the ongoing construction of the Mississauga gas plant. And there's a number of details and dates that come forward. It makes reference to the Auditor General's estimated cost of relocating the gas plant. It talks about September 10th, the Ontario Power Authority awarding a contract, City of Oakville opposing the building of the Oakville gas plant, and on we go. And in this case, the plaintiff was the campaign co-chair of the 2011 Ontario Liberal Party campaign that made a decision to cancel the Mississauga gas plant. As a member of the Executive Council of Ontario, the plaintiff also signed the cabinet document that authorized the Liberal government to enter into arbitration with TransCanada over the cancellation. We go into a lot more detail, but my point is a litigation letter, a chill lawyer's letter that said cease and desist any further discussion about the process surrounding the Mississauga and Oakville gas plant cancellation is a perfect and obvious example of Bill 52. This process began, as I stated earlier, in 2011, and here we are in 2015, where it has gone no further in the court. The court has not reviewed whether this is actually moving forward, and yet we're talking 4 years later, it's still hanging over our heads. Bill 52, if passed in its current process, this would not still be on the courts. This would not be bogging up the system. This would not be part of a process of continuing to be that threat that reminds my two colleagues and the party that I belong to that they're supposed to talk about what clearly was government policy of community and general interest, and Bill 52 would have allowed us to have those very public, needed conversations without the worry of having any of their comments taken through a lawyer's letter. So I just highlight this example as one reason why we need to move forward on Bill 52. As many people in this chamber know, we've had a number of different examples, a couple of private members' bills, and at least one other government bill where we have attempted to move forward on making changes to the current strategic litigation against public participation process. So we do need to continue with that idea. The other thing, I'm not going to give a carte blanche. The entire legislation is great. There have been some concerns raised, without a doubt. So the forestry industry in Northern Ontario, of course, has gone through some terrible economic challenges in the last number of years, but they're not all related to the economy. Some of them are related to some very strategic and pointed opposition from certain groups. And one of the recommendations of amending Bill 52, which would be to ensure that when we are talking about protecting the public from public consultation or the ability to participate, is that we ensure it's not one large financially backed entity against a business or an individual or an industry. So perhaps we could look at some amendments that would, well, I'll just read what the recommendation is. If the legislation could be amended to specifically apply to volunteers and smaller community organizations with annual budgets of less than $100,000. That was one recommendation made by the Federation of Northern Ontario Municipalities. So I would hope that when we are at the committee stage, we can look at those types of amendments that ensure this is, in fact, about protecting the individual's right to participate and not an opportunity for large financially backed organizations to be protected from saying whatever they want about whomever they want. The Act is also amended to establish qualified privileges that apply in respect to an oral or written communication on a matter of public interest between two or more persons who have a direct interest in the matter, and applies regardless of whether the communication is witnessed or reported on by media representatives or other individuals. It's actually an important amendment as far as completing the goal of Bill 52, actually protecting public participation. I think we all understand that the world is a very different place now with tweets and Facebook posts, and we can't just be looking at the more mainstream traditional forms of public participation, i.e. newspaper, radio, and TV. As it stands currently, there are currently privileges regarding oral or written communication that are possessed by individuals who have a direct interest in a matter of public interest. What Bill 52 does is amend the Libel and Slander Act to extend these privileges to individuals, reporters recounting or repeating any discussions in the matter by those who do possess a direct interest in the matter. This is important because if a journalist is writing a story on something an individual said at a public meeting, while that individual could have been discussing a matter they had a direct interest in and be fairly protected from legal action, the journalist would technically not be protected, as they arguably do not possess a direct interest, but rather an indirect one. Journalism and reporting is a tenet of a healthy democracy. If we're serious about protecting public participation, we absolutely must also protect the sanctity of the press to report on the news of the day and on the issues important to their local citizens. Bill 52 is a necessary and much-needed improvement for dealing with SLAPP litigation. Just like I said in my previous discussion on Bill 52, in which I discussed examples of cases that could very well be considered SLAPP lawsuits, I would like to continue on that note. There's an example that, many of us are quite involved in or are quite aware of, and that is a young woman named Esther Reitman. And Esther Reitman lived, I should say, in southwestern Ontario, and was very publicly opposed to the sightings of some industrial wind turbines in her community. Not unusual. We have many individuals across Ontario who have raised various concerns, various issues with the siting and placement of IWTs, industrial wind turbines, in their communities. What makes Esther Reitman's example unique is, again, she was sent a lawyer's letter, again saying, cease and desist, we don't want you to talk any more about this project, and if you do, you will be sued accordingly. And then there was a very large number that was the threat to say, if you continue, then we're going to sue you and basically take you for everything that you have and then some. It was effective in the case of Esther Reitman, unfortunately. She ultimately ended up selling and moving out of the province. However, that lawyer's letter, that litigation chill, is still on the books. The originators of it, the owners of the IWT proposal, have not removed that chill, that concern, that stress. And while I have not personally been the victim of one of those letters, I can imagine what it did to Ms. Whiteman, her family, and quite frankly, anybody in the community who wanted to continue the opposition to the industrial wind turbines. It's a very, very effective tool to ensure that people stop talking about projects that they are opposed to. And you know, we can get pretty specific here, talking about individual pieces of legislation, but the reality is most of us understand everyone deserves and has the right and should use it. I mean, we as legislators often tell our community, our students, our municipalities, get involved. If there's something that is concerning you that's happening in your neighborhood, in your town, in your municipality, get engaged, get involved. If we do not offer some legislative protection in the form of Bill 52, we're sending mixed messages, because we are not protecting people who want to speak out publicly on items that are happening that impact their community and impact their ability to enjoy their property and their community. I still think it's a sad state of affairs when Ms. Whiteman was left with no choice, in her mind, was left with no choice but to sell her property and move out of the province so that she would not have that threat of litigation held over her head while she was attempting to get a remortgage, while she was attempting to make any expansions or changes to her business models. It's all there in the public realm where there is a very substantial claim against her simply because she wanted to share in a very public forum why she did not support the siting of wind turbines, industrial wind turbines, in her community. And it's a sad state when here in Ontario people don't have the opportunity to speak out against issues, whether it's cancellation of gas plants, as is the case with my colleagues from Niagara, West Glanbrook, and Nepean Carleton, or in the case of Ms. Whiteman with industrial turbines. We need to make sure that our legislation is protecting an individual's right to speak out. And I understand that within this chamber, we are all very, very well protected, but that's 107 members, Speaker. And it doesn't compare to what we have a responsibility to the other 13 million who live in the province of Ontario. It shouldn't just be what we say in here that is protected. It should be the ability for everyone, regardless of where they are where they're living in the province and what role they play, whether it's public or private or in business, that they should also be protected. So it is a fine line. You know, you can't, nobody wants to get to a stage where I can say anything about anyone and be above the law. There has to be the opportunity for people to protect their good name, their business's good name. And I think Bill 52, with that 60-day opportunity, where it would be reviewed and it would be decided in a very systemic way. Is this actually chill? Is this actually slander? And if it is, absolutely go through the courts, take it through the process. But if it isn't, shut it down. And we wouldn't then have these lawyers' letters and litigation from, what did I say, 2011, still sitting in a court docket, bogging up our very challenged court system in March of 2015. And, you know, make no mistake, this is not about any intention of Ms. Wynne to bring Tim Hudak, Lisa MacLeod, and the Ontario PC Fund to court. This is all about saying, you keep talking about the Mississauga gas plants, and we're going after you. And it was a very, to coin the phrase, strategic opportunity for them to threaten and to scare people out of talking about the process behind the Mississauga gas plant. Mercifully, we have been able to ignore that threat, I think probably because my colleagues are MPPs and understand how the law works, but it doesn't make it any more, it's not right that that is still sitting there from 2011, and here we are 4 or 5 years later. So with that, I'm going to wrap up, but thank you for your time, Speaker.